DC ruling, people. You knew it was going to happen. I mean, you knew the DC Court of Appeal was going to rule this way before they did. SCOTUS says we're not hearing the expedited direct to the Supreme Court adjudication of Trump's presidential immunity claim in the DC. Are we calling it the insurrection case? We'll call it the insurrection case. You'll recall that Jack Smith, who really saw his March 4th deadline for a trial disappearing into thin air, says, well, shit, okay, we now know that the case has been suspended in DC pending an adjudication on Trump's claim for presidential immunity. Judge Chutkan can't do anything about it until they rule on that. So Jack Smith then says, expedite this to the Supreme Court of the United States of America, of these United States of America, so they can adjudicate on it, hopefully send a ruling back so that we can hopefully stick to our March 4th, March 5th deadline, whatever it is, the Monday before the Super Tuesday. Not going to happen. Not going to happen. But Supreme Court says, no, we're not doing that. Go through the regular course. We can benefit from the reasoning. And I'll put reasoning in quotes of the Court of Appeal. And they sent it back to the Court of Appeal, and the Court of Appeal just came down with their decision this morning. And in case any of you are going to be unpleasantly surprised, it's a steaming pile of judicial horse manure. The only question now, I'm not sure what happens now if it goes potentially to an en banc review, or en banc, if you want to pronounce it properly, a bench review of more than 3 judges from the DC Court of Appeal. I don't know if that happens before the Supreme Court has to take it up. Supreme Court, I suspect, is going to take it up. And they damn well better overturn this steaming pile of judicial dog manure of a judicial decision. What I've done to facilitate things for everybody, I've done the hard work, I guess, or the tedious work so that you don't have to. I just need to make sure I get my tweets in chronological order. I screen grabbed 12 screen grabs from this decision, just to highlight. Starting at the beginning, these are in order. I just should have kept the pages to the extent I could have. This is from the ruling where it says, and I'll read it. Former President Trump's claimed immunity would have us extend the framework for presidential civil immunity to criminal cases and decide for the first time that a former president is categorically immune from federal criminal prosecution for any act conceivably within the outer perimeter of his executive responsibility. This is why I highlighted this. They summarize the 3 grounds that they're going to have to get around to deny him presidential immunity. So, talking about motivated reasoning, you're going to see here, they set out what they have to overturn before they overturn it, and then you can just argue backwards. He advances 3 grounds for establishing this expansive immunity for former presidents. 1, Article 3 courts lack the power to review the president's official acts under the separation of powers doctrine. Separation of powers. He was acting within his presidential authority when he was trying to ensure the integrity of elections, or, if you ask Jack Smith and others, when he tried to overturn the president's election through insurrection. 2, so Article 3, separation of powers. Okay, how are they going to get around that? 2, functional policy considerations rooted in the separation of powers require immunity to avoid intruding on executive branch functions. Okay. And 3, the impeachment judgment clause does not permit the criminal prosecution of a former president in the absence of Congress impeaching and convicting him. I thought the third one was certainly the strongest. Okay. These are the hurdles they have to overcome. You get into the separation of powers doctrine, and they summarize it so that you can know what to say. And they go on for pages and pages. The President of the United States, quote, occupies a unique position in the constitutional scheme. Okay. Settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the President of the United States. Okay, fine. We therefore conclude Article... They go through their whole thing. Okay, they got to get to the conclusion. Article 3 doesn't bar them from persecuting. They have power to interfere with presidential executive authority, whatever. We therefore conclude that the Article 3 courts may hear the charges alleged in the indictment under the separation of powers doctrine as explained by Marbury and his progeny in the applied and analogous context of legislative and judicial immunity. The indictment charges that former President Trump violated criminal laws of general applicability. Acting against laws enacted by the Congress, he exercised power that was at its, quote, lowest ebb. Former President Trump lacked any lawful discretionary authority to defy federal criminal law, and he is answerable in court for his conduct. Okay, fine. Agree with it or disagree with it. I mean, you've heard the argument here. If you break the law, no one is above the law. And when he's out of office, he can't just say, I was acting as president when I pulled out, a gun and killed the chef because I didn't like the chowder. One would think that you'd still need to be impeached before that. Otherwise, what's going to stop rogue prosecutors from, after the fact, harassing former presidents where they weren't impeached while they were president? What's going to stop that? Nothing. And I'll make that point later on. Functioning. Okay. Then we got, this is item 4 of our first set of notes. We note that at the outset of our analysis is specific to the case before us, in which former president has been indicted on federal criminal charges arising from his alleged conspiracy to overturn federal election results and unlawfully overstay his presidential term. Oh yeah, because he did that after all, right? We consider the policy concerns at issue in this case in two respects. First, we assess possible intrusions on the authority and functions of the executive branch and the countervailing interests to be served as those concerns apply to former President Trump's claim that former presidents are categorically immune from federal prosecution. And that was the argument. I could kill someone, and if I did, presumably I'd be impeached for it. Unless you're Obama and you extrajudicially assassinate an American citizen, don't worry about it, Big B, you'll be fine. Opie, Big O, you'll be fine. No, Barack, Big B. Big B, Big O, whatever. No, that you can do. Kill an American citizen through a drone strike in a foreign country with no judicial process. Bada bing, bada boom, you're fine. Illegally smuggle guns to cartels in South America and then result in the death of a border agent, you're fine. We conclude that the interests in criminal accountability held by both the public and the executive branch outweighs the potential risks of chilling presidential action and permitting vexatious litigation. Of course you do now, because you're never going to do this to a Democrat. Yeah, we're not worried about, chilling actions and vexatious proceedings, because we're never going to do that to one of our own unless there's a good reason to. And, Joe Biden might be next on the chopping block. We examine second, I think that's it. So that's one set of tweets. Number two under this decision, and this is one of my favorites. Let me see this, number 2, number 3. This was the part that I loved, and this is the one to highlight forever. There is also a profound Article 2 interest in the enforcement of federal criminal laws. We all agree this. Nobody's above the law, right? This is all subject to how they get around the double jeopardy impeachment, because all of this could be true. Yes, we need to enforce the laws. Nobody's above the law. But if you were not impeached for high crimes and misdemeanors, what authority do we have? Or not just that. If you were actually acquitted, what authority do we have to then come after you again for ostensibly the same charges? Oh, they're different. There's also a profound Article 2 interest in the enforcement of federal criminal laws. The president has a constitutionally mandated duty to take care of the laws, to take care that the laws be faithfully executed. And my point with this was, holy crab apples, is this funny in the context of Joe Biden not enforcing immigration laws? Holy crap, is it funny? They'll never come after him unless they want to, because he's a demented old fool and they need a useful tool instead. The federal prosecution of a former president fits the case, quote, when judicial action is needed to serve broad public interests, end quote, in order to, quote, vindicate the public interest in an ongoing criminal prosecution. Listen to this. The risks of chilling presidential action or permitting meritless, harassing prosecutions are unlikely, unsupported by history, and, quote, too remote and shadowy to shape the course of justice. Holy shit, what delusional universe are you living in, DC Court of Appeal? I'm sorry, what did I say? Unsupported by history? It's supported by the president, by the present. Indictments in Georgia, indictments in New York, indictments in DC, indictments in Florida. Nothing but judicial harassment. Oh, it's unsupported by history. Oh, and it's too remote and shadowy to shape the course of justice. It's in your face right now. And by the way, surprise, surprise, you're a part of it. Oh, it's never been done before. Yeah, because you guys have never been rabid animals before. Now it's happening all the time. The president, of course, also has a duty under the take care clause to faithfully enforce the laws. I just love that because, I said sarcastically, well, this will never come back to bite them. And it won't, because they will never use it to bite them in the ass unless they really want to. They'll come after Mayor Eric Adams. No one's above the law when he's politically, when there's a politically good reason for them to do it. They'll come after Cuomo when there's a good political reason to do it. Now, this one I brought for a specific reason. In drafting this is the impeachment and judgment clause. Okay. In drafting the impeachment and judgment clause, to the extent that the framers contemplated whether impeachment would have a preclusive effect on future criminal charges, the available evidence suggests that their intent was to ensure that a subsequent prosecution would not be barred. Oh, really? They're inferring intent as to what they did not intend to be following from an acquittal on impeachment charges. Let's just see how they get there. And then it was, okay, scope. Okay, well, I guess that might do it for that one. All right, now we're going to end and we're going to get to the last one, which is the impeachment. How do they get around the impeachment? How do they get around the double jeopardy? They get around the impeachment to say, well, yeah, the framers never intended to require a conviction on impeachment in order to facilitate, permit, authorize subsequent criminal charges. They never intended that. And even if they did, well, he's not being charged for the same thing for which he was already acquitted in impeachment. It's the mental gymnastics of scoundrels. All of this leads us to conclude that under the best reading of the impeachment judgment clause, a former president may be criminal prosecuted in federal court without any requirement that he first be impeached and convicted for the same conduct. Oh, but don't worry, by the way, even if you're not convinced by that, even if we assume that an impeachment trial is criminal under the double jeopardy clause, the crimes alleged in the indictment differ from the offense for which Trump was impeached and acquitted. There's nothing you can do. There's absolutely nothing you could do to get around this court coming to the conclusion to which they wanted to come. In determining whether two charges are the same for double jeopardy purposes, the same elements test, known as the Blockberger, it's an unfortunate name, if each offense contains an element not contained in the other, the offenses are different. And then we get into it. Bottom line, mental gymnastics, they get there. Former president does not dispute this analysis and instead contends that rather than applying the Blockberger test, a subsequent criminal prosecution cannot be based on the same or closely related conduct as an unsuccessful impeachment. No. Too bad. But the argument is foreclosed by case law. The, quote, same conduct rule is wholly inconsistent with the Supreme Court precedent and with the clear common law understanding of double. Thus, well-established law interpreting the double jeopardy clause undermines rather than supports former President Trump's argument that he may not be prosecuted. Perhaps recognizing that normal double jeopardy rules disfavor his position, he claims that the impeachment judgment clause incorporates, quote, double jeopardy principles that are distinct from double jeopardy. But if the double jeopardy principles he invokes are unmoored from the double jeopardy clause, we are unable to discern what the principles are or how to apply them. He thus fails to establish that his Senate acquittal bars criminal prosecution. Of course he does. Thus, in conclusion, we have balanced the former President Trump's asserted interest in executive immunity against the vital public interests that favor allowing this prosecution to proceed. We conclude that, quote, concerns of public policy, especially as illuminated by our history and the structure of our government, end quote, compel the rejection of his claim of immunity in this case. In this case, we have also considered his contention that he's entitled to categorical immunity from criminal liability for any assertedly, quote, official, end quote, action that he took as president, a contention that is unsupported by precedent, history, or the text and structure of the Constitution. Finally, we are unpersuaded by his argument that this prosecution is barred by the double jeopardy principles, end quote. Accordingly, the order of the district court is affirmed. There you got it, people. Do you ever see what it's like to argue with a wall? This court was a judicial wall. It was a judicial brick wall. Like that meme, the guy talking to a wall trying to convince it. They had their conclusion. That could have been drafted before any proceedings. All claims denied. Nothing to see here. Go on. Supreme Court. Oh, yeah.